Well, hello, friends. Welcome to a late night edition of Uncivil Law. I hope you're well. I'm well. I hope you have a drink in hand. I have a drink in hand. We got this wonderful pre made wine margarita. It's wine that tastes like margarita. It's fantastic. Recommended. So our friends here responding for Toddy decided to wait till pretty much the last minute. I've been checking on it periodically, and they decided to file sometime in the last hour, really cutting it close, because they had to file by midnight local time, which of course this is West Coast, so that was 2 hours ago. But they have filed their response, and they filed several things actually. So they filed their response, which includes the response and also includes a declaration, several declarations, in fact. We got a declaration from Toddy. We got a declaration from James. We got a declaration from someone named Kim Fulmer. Who's a Kim Fulmer? I don't know. A Macy Storm, Hope Walker, and some other things. So we will read this. We will read the response, and we might read some of the depositions or declarations, I guess, because they're not technically depositions, declarations. And we'll go from there. That'll be fun. And we'll see how it goes. And we'll just drink heavily, and we'll see how that goes too. That'll be fun. Okay, great. Let's do that with our response from Tati. The plaintiff's motion to dismiss. Now, I will give the standard disclaimer that this is written in the voice of Tati because it's the plaintiff's motion. So therefore, when we are applying our skepticism hat, right, because this is written in her favor, because it's, of course it is, it's designed to be, since this is written to favor her, we will apply our skepticism hat in the opposite direction, right? So we will apply our skepticism and credulity to say, well, that might not make sense. So we will try to read things in the light most favorable to without a crystal ball, because that's the only way that this is fair, because it's written to favor Toddy. So we'll read it the other way around so that it's fair, right? We'll adjust for that. Okay. So before I get accused of boy toy or whatever shit, I just want to say that we're going to be skeptical because of course we are, because it's written specifically to be biased for Toddy. Great. All right, so we'll see how this goes over. All right, so let's see what we've got. I can't win sometimes. Over the past 19 months, the defendants, Paulson and Without a Crystal Ball, have engaged in a course of conduct specifically aimed at harassing Tati, James, and Halo Beauty Partners, LLC. Through defendant's social media communications, including publishing defamatory statements about public plans in at least 80 YouTube and Instagram videos and more than 100 postings on Twitter and other locations on the internet. It does sound like maybe we should do other things with our time. 80 videos about one person is a lot, I would think. This case arises out of these widespread incidences of defamation and ongoing campaign of harassment defendants have waged against plaintiff. Not bad. We're setting the tone pretty well. Defendants filed a motion to dismiss the complaint asserting jurisdictional, failure to join necessary party, and failure to state claim arguments as their basis for dismissal. And then they have a little footnote here. As defendants fail to cite to 12B at any point in their motion, plaintiffs assume that the procedural basis for the objections are made pursuant to B1, B2, B6, and B7. I do like that. A little burn there. It's like, well, since you didn't tell us, we'll just assume it. That's a nice little note there on the footnote. As a basis for a dismissal, in the motion, defendants attempt to distract the court from defects in their argument by relying on inadmissible evidence and extensively relying on wholly irrelevant facts. Okay, you're going to have to justify that one, but all right. In addition, defendants rely upon the misleading declaration of Paulson and her attorney to support defendants' jurisdictional arguments, as well as obsolete, inapplicable federal case law. Ooh, ouch. That's a burn. It's like you didn't use the most current case law. You didn't shepherdize your case. And that's not a good sign. Although we didn't see the greatest legal document that we ever saw in our lives from KJ. So it's not completely surprising that some of their law might be out of date, right? And California law to supplement their jurisdiction and failure to state claim arguments. Finally, defendants failed to acknowledge that deletion of evidence, particularly YouTube videos, destroyed evidence relevant to their jurisdictional objections. Maybe. I mean, there is something there to be had. There is this idea of an adverse inference that you could have. So maybe that's where they're going. That because they deleted it, the information would have shown that there was jurisdiction, so we can infer the opposite. So if you can't do this in criminal law, but you do it in civil law, right? So if you don't have evidence in criminal law, you don't have it. In civil law, however, you can get an adverse instruction. So if you're responsible for deleting evidence, the other side can come forward and say, we want the adverse inference. In other words, we want to say what we said it would have said because they deleted it. And we could have seen what it said, but they prevented it. So let's just assume that we're right. And you can actually get that in a civil case. So maybe that's where they're going with that. The court should deny a motion to dismiss because defendants have sufficient minimum contacts with the forum through their research, publication of defamatory statements in the forum, and targeted known residents of the state of Washington. I hope research really doesn't give... I really hope research does not give jurisdiction. If it does, I'm in a lot of trouble. Because I do research all over the place for legal things all the time. Do I suddenly have jurisdiction? Does every court suddenly have jurisdiction over me for my legal research? Do I need to give up this hobby and do something else? Because I don't want to have jurisdiction to every single state. That sounds like a bad plan. So I really hope research alone does not jurisdiction make, or I might have problems. The court has subject matter jurisdiction over all the plans through diversity jurisdiction, which is not destroyed by the inclusion of defendants. That's fair. There's no requirement to join parties under the rule. That's probably true. And plaintiffs satisfy the requirements of the rule and states claims for relief. They're plausible. Okay. Defendant Paulson and Without a Crystal Ball announced their campaign of harassment against Toddy and their plan to dig into her background and expose her in a video uploaded to YouTube on or about May the 31st of 2019. In that video, defendants state they were digging into Toddy's back. This is just some more like tea. It's a little bit more tea. I'll let you know when we get to something like legally important. We're just sort of in tea and background, a little shading, which is typical in lawsuits. But it's like we'll let you know when we get past the shade tea hour. Although most of you guys come for the tea, so I don't want to deprive you of your tea time. Anyways, the defendants state they were digging into Toddy's background and looked all over the place, everywhere. Defendants also referenced civil judgments and tax liens they found. Well, that might be a basis for truth, right, in the underlying matter, or at least a reasonable belief in the truth of the underlying matter. If they found judgments that they were making an opinion based on, that might be good for defamation. Defendants then go on to indicate they conducted more in-depth search than a simple background check. Okay. Defendants also state that people can go state to state and try to pull stuff off, and that people go to different databases within states to find information, which defendants admit is what they did to get personal information regarding Toddy and her family. Okay. Again, I really hope that this does not jurisdiction make, or I have problems. Defendant also assert that Toddy's address is online too, but defendants were not going to provide that. Okay. Defendants further state they continue digging more and more information, going through marriage records and birth certificates, specifically asserting it was weird that they could not find Toddy's birth certificate. I don't know if it's that weird. Many states don't provide it if the person is still living. Toddy was born in Washington. Defendants then go on to discuss the extensive public records and social media pages they searched regarding Toddy's parents, Washington residents, and her two sisters. One is a Washington resident, lamenting how they could not find information regarding Toddy's father, which led defendants to theorize Toddy's father is either dead or in the mafia. Well, that's one hell of a conjecture from we couldn't find information to they're dead or in the mafia. That's a lot of conjecture, man. We can't find the information, so they must be in witness protection? That's a bit of a leap. Yeesh. Subsequently, in a video entitled The Past James and Toddy Westbrook Don't Want You to Know, uploaded on YouTube on or about June the 2nd of 2019, defendants continued their campaign of harassment and planned an expose on Toddy and her family. How exciting. In that video, defendants discussed the research they have done into Toddy's childhood and family in Washington. It does sound like we have a bit of an obsession over Toddy, a little bit. Which isn't necessarily illegal, but it is maybe a little potentially creepy. Defendants also specifically talk about Toddy's two sisters and mother, who are private Washington citizens. Fair enough. Fair enough. They further examine Toddy's personal history in Washington and connections to Washington. Defendants also assert they have documentation for all the information in this video, including court records from Washington State that they found through 3 weeks of nonstop research to find all the information. I mean, to the extent that they are relying on court records as a basis for what they're saying, then that might be a suitable basis to get past defamation. Okay. Defendants, not that KJ asked to dismiss, as we all learned from me beating my head against the wall, because KJ could have made a motion to dismiss based on public figure and based on underlying truth. That would have been super helpful. But since she didn't do any of that, I guess it's irrelevant. So I don't even know what I'm talking about. Defendants even show a public document confirming Toddy and James' residence was in Washington at the time of the video. In the documents, defendants expressly redact the house number, street, and city of Toddy and James' Washington address, but leave the state designation, which is Washington. Well, just because they have a house there doesn't necessarily mean they reside there, but whatever. In the video, defendants claim they don't want to put Toddy's and James' address out there. They don't want to show the viewers where Toddy and James live. Don't dox. That's a good idea. At the end of the video, defendants thank their videos for sticking with them in their 2-part expose. If they uncover more information, they will deliver it to the viewers. Super, super exciting. Yeah. K Black in chat points out that apparently in Washington, anyone can get a birth certificate until January the 1st of 2021. So apparently in Washington, anyone can get a birth certificate for anyone in Washington. I was born in Pennsylvania. That is not a thing you can do in Pennsylvania. So yeah. How are we all doing in chat today? Are we pumped? Are we super pumped for the Toddy tea? I'm doing my best. I'm doing my best here to provide all the excitement. At 2 a.m., it's 2 in the morning, Central Time. I'm here. I want to take note for the record that I did DM Emily, as I promised I would, and I assume that she has well since gone to sleep, but I did try. So, wherever you are out there, Emily, I hope your dreams are going well right about now. More recently, in a video uploaded to YouTube on or about September the 22nd, defendants admit that Toddy and James moved back to Seattle actually a while ago. Defendants referenced Toddy and James' purchase of a house in Los Angeles, however, during the entire time they owned the Los Angeles home, neither Toddy nor James lived in Los Angeles or spent a night in the house, which kind of proves the point of just because you have a house there doesn't mean that you reside there. So even if they knew that there was a house in Washington, it doesn't exactly prove that they knew that they lived there. Those are different things. Yeah, totally pumped. Yeah. Karen says she's pumped. Yeah. Rachel pumped. Yeah. Yeah. Law Time, First Domino. Yeah. Laurie, American Princess, Rachel, Heidi, Louisbell. Rachel says she's asleep. I know she's asleep. Yeah. Very pumped. Very good. Sleep is for the weak. I agree completely. Since May of 2019, defendants have published approximately 80 videos as well as 100 internet postings on Twitter and other social medias maligning James, Toddy, and Halo. Yeah, this is kind of tea-ish still. This is still in the prelude of let me tell you about how they're horrible, horrible people. All right, so now let's get into the defendant's Washington viewership and claims harm in the forum. All right, so we want to find harm, preferably in Washington. That'd be great as a basis for jurisdiction. That'd be helpful. So let's see what we got. Defendant's viewership includes residents of Washington. Yeah, but it includes Washington viewership of probably all the places. And contrary to misleading statements in the declaration, defendants know their content is published to viewers in Washington. It's published on the internet. It's everywhere. During multiple live stream videos in August and September of 2020, 3 to 4 months before filing the declaration, Washington residents expressly identified their Washington locations to defendants in a live stream chat. Okay. In addition to a live stream video dated August the 30th of 2020, defendants specifically interrupted the live stream to acknowledge and say hello to Patricia from the state of Washington. That is some weak sauce. That is some weak sauce. So, yeah, why doesn't everyone right now just type the state that they're talking from, and I'll acknowledge each one of you independently, and that will mean that I have jurisdiction in all those, and that means I can be hauled before the courts in all those places, because now I know that I'm talking to someone in each of those jurisdictions. That sounds like a good thing. Everyone can give me their state, and I'll acknowledge each one of you. And now suddenly, I'm subject to jurisdiction in all those places because I know that my content is being published there. But it's on the internet anyway, so I know it's being published everywhere. So I don't understand what the point is, but okay. It seems a little weak sauce to me. We got some Missouri. Who else we got in chat? I'm in Texas. Well, we got some Missouri in chat from Joe's Med. Who else? California from Thomas. Illinois Plastic. Alaska. Ooh, nice to have you, Sydney. California from Internet Commentator. Hey, nice to have you here. Don't know a lot about Alaska. I hear good things. Pittsburgh, Pennsylvania from Ashley. Ola Murr from North Carolina. Alberta Calendar from Michael. Illinois from Heidi. Mark Hellspot, North Carolina. Kanakistan from XXX Windsor. Well, I guess XXX Windsor was kind of a clue. Up Unicorn Cupcake. Okinawa. California. A few of you from Australia. Apparently I can be hauled before the Australia courts now. Some Melbourne, Missouri, Lang of Kangaroo. Yeah. Arkansas, Seattle, Texas, Sweden, Virginia, my former home. Ohio, Akron. I went to law school in Ohio and Akron. California, Pennsylvania, Colorado, Seattle, New South Wales. Hello, New South Wales, Tennessee, Florida, Texas, Idaho. Yeah, we got a whole bunch of people. New Hampshire, Nashua. Really? Nashua, New Hampshire. Don't see that very often. How does it feel to be like the most important political constituency in the world? Do you feel a sense of ego from being from Nashua, that your vote is more important than everyone's vote because you're from Nashua, New Hampshire? All the candidates come to you first because you're special. Ohio, Scotland. We got some Scotland here. That's nice. Anyone from Austin, Texas, other than me? We get together for some Austin. Gets any Austin people? Go Zips, you got it. That's right. Go Zips, you got it. Oh man. All right, where were we? Moreover, Defendant's publication of their harassing and defamatory content about Toddy, her family, and business to Washington viewers caused such viewers to stop supporting Toddy. They stopped ordering Toddy's Halo products. They stopped watching Toddy's mod to his YouTube channel, and they stopped following Toddy's social media, which damaged Toddy, James, and Halo's best interests. Okay, first of all, there's a causality problem, and second of all, really, that's enough. So the fact that I'm now talking to all the states that I just mentioned, and now I'm covering this lawsuit, that maybe because of some of the things I report, some people will cause to watch or not watch some of these people. So maybe based on my analysis, Toddy's membership will grow or not, or KG's membership will grow or not. Am I suddenly responsible for all that because I'm talking to a wide range of audiences? My liability apparently is growing immensely with every passing moment. Yeah. Victoria. Some Tennessee, San Antonio. Nice to have you. Houston, Wales. Nice to have you. Waco. Malaysia. You got a reservation in California. That's nice. Yeah. Defendant's Tati-related content caused Washington to think less of and develop negative feelings toward Toddy, James, and Halo. Yeah, not sure about that one either. That seems some weak sauce. That seems some pretty weak sauce. That's a little weak. Yeah, one time in chat, someone said they're from Washington, and the host took the time to say, "It's nice to see you from Washington," and therefore they're purposely ejecting themselves into Washington. Seems a little weak. Seems a little weak to me. Let's see if it gets any better. Toddy and James moved back from Washington to California late 2018, signing an 18-month lease agreement for their current resident, which lease term began in December the 1st, 2018. The lease term was extended. Again, just because you have a lease/home there doesn't mean that you live there, reside there, or domicile there. But okay, it's nice to know you had a lease there, I guess. Okay. In fact, Toddy's Instagram account has a picture of Toddy in their current residence, which was posted on February 18th, 2019. From this one photo, we're supposed to conclude that you live there full time and reside there. Toddy and James paid taxes in Washington for the 2019 tax year and will pay taxes in Washington for the 2020 tax year. They own investment property in Washington, and their personal bank accounts are located in Washington, which sounds suspiciously like you might be domiciled there. This could be a really really geeky fight on where exactly they're domiciled. I can already feel the fight coming on. This is not really relevant at any time. The only time it's really relevant of domicile, well, for voting, because you can only vote where you're domiciled. And the only other time it really matters is if you die without a will, because then we have to figure out what state you were a member of to figure out where your estate will be probated. And yeah, now I'm having nightmares back to like law school where we had these hypotheticals about, people moving state to states and where do they really live? When does domicile attach? When we're moving from state to state and someone dies along the way without a will, because of course they do, because we have to make the question as complicated as possible. That kind of thing. Additionally, Toddy and James have 3 businesses incorporated in Washington: Toddy Inc., Toddy Halo, and Toddy Cosmetics. The Washington citizenship of these companies are publicly available and easily found on the Secretary of State database. Fair enough. All these corporations also have business accounts in Washington. Toddy and James don't own any property in California. Wait a second, but you said they leased, which is not the same thing as owning, I guess. I don't own any property in Texas, so what? I lease. It counts. All right, they don't own any property in Texas, so what? I don't own any property anywhere. Toddy is the chief executive officer of Halo and manages nearly all of Halo's businesses in Washington through a Washington corporation, Toddy Halo. Likewise, James is the chief operating officer of Halo. That's nice. How nice. Toddy has 9 million subscribers, approximately 2.5 million followers on Instagram, and 1.3 million followers on Twitter. Nice if you can get it. Please send me some subscribers, Toddy. She does not manage her social media accounts on her own. Yeah, that makes sense. So, all you people who thought you got messages from Toddy, I hate to tell you, but Toddy has said in her own declaration, she does not talk to you. Toddy does not love you. Toddy does not love you or talk to you. She cannot be bothered. Sorry to break the illusion, people, but you are not talking to Toddy. I know it's very sad. You are, however, talking to Uncivil Law. Many of her social media posts are created by others, including her social media assistants. Moreover, because Toddy is a highly recognizable figure, which screams public figure, which would be really helpful for the defamation lawsuit, I'd like to point out. Highly recognizable figure. It's like, yeah, public figure, hello, knock, knock, hello, McFly, hello. For her own personal safety, she will often post at random times when she's not in the reference location, so the public does not know exactly where she is. Okay. That's some weak sauce so far. I don't know if it's going to get any better, but so far I'm not super duper impressed with this. Let's see if it gets any better. Despite the fact that the court has original subject matter jurisdiction over the entire action consisting solely of Washington civil state laws on the basis of diversity, defendants erroneously argued court somehow lacks subject matter jurisdiction over a civil harassment claim. Did they? I don't remember that, but okay. Defendants further erroneously assert this court lacks subject matter jurisdiction over the action due to the inclusion of the defendants. Okay. Before making any ruling in this case, every court, even the Supreme Court, must determine independently that it has subject matter jurisdiction over an action, even when no party has challenged it. Fair enough. Defendants' arguments ignore the fact that both the Western District of Washington and the Ninth Circuit previously have determined that federal courts have subject matter jurisdiction over civil harassment brought under this. I'm sure they do. I don't care. It's diversity jurisdiction. It's fine. They have jurisdiction over this claim. I'm sure they do. I don't care. In fact, the Western District of Washington expressly rejected the argument. Because of the Washington State Superior Court has original jurisdiction over civil harassment, the federal court is not precluded from also doing it. Yeah, that makes total sense. You can bring all your claims along in the federal court on diversity. I don't know why someone argued. Did they even argue that they couldn't bring it along? I don't remember that argument. Did they make that argument? It doesn't make sense, though. You should be able to bring it along. There's no reason you couldn't. Moreover, even if this court did not have original subject matter jurisdiction, the court will have supplemental jurisdiction because the defendant claim and civil claim are so related they form part of the same controversy. Yeah, I'm good with that. Unlike Ferguson versus Wade, in which the federal trial court and Ninth Circuit considered a civil harassment suit brought under whatever, the case relied upon by defendants are inopposite, which is to say, does not read on this. In Karga versus City of Reno, the court was analyzing a Nevada public records request statute, not a Washington civil harassment statute, which, that difference is kind of neither here nor there, because the question is like the applicability or the logic of it, of one onto the other. So yeah, one is a Nevada public records request, one is a Washington civil harassment statute. Can you read the logic of the Nevada public records request case on the Washington civil harassment? Maybe. I mean, they are different things, but the question is if the logic of it is different or not. And determined it could not exercise supplemental jurisdiction because the plaintiffs had not brought a claim for relief based on violation of the statute. Which, fair enough. If you don't raise it as a basis of your lawsuit, then the court won't hear it because you didn't complain about it. So I'm not going to have jurisdiction over this because you never actually asked me. Okay, that makes sense. In some other case, the court already determined to not have subject matter jurisdiction over the party's state law claims and dismissed the action. In an effort to create subject matter jurisdiction through a federal question, which would be the alternative to diversity. So if you can't do diversity jurisdiction, then one of the other ways to get before a federal court would be a federal question. So you have some sort of federal interest. So a good example of this would be a copyright claim. So if I have a copyright claim, I can bring that into federal court because it's a federal law. So that would be a federal question, right? As opposed to, so you have all your state law torts, like your standard stuff, like, well, most things are state law, but defamation is a good example, and some of this other stuff is good examples, but like federal question, like copyright. So if I have a copyright issue, I can bring it into federal court. So that would be my other way of getting there. The plaintiff filed such an amended complaint alleging a federal claim of civil harassment. Federal? Really? Finding there's no such claim under federal law, and I can't think of one off the top of my head, the court dismissed the claim, noted that due to lack of diversity, which would be the alternative to federal question, it could not consider the state law claim, right? Because I don't have jurisdiction, I can't hear it. Yeah. The court's ruling did not find the plaintiff could not bring the harassment under Washington state law in a federal court in a diversity case. Right, those are completely different, right? So in the one case, you didn't raise it, so I'm not going to hear it. In the other one, I don't have diversity jurisdiction. You want to try to squeeze this into a federal question, which it's not a federal question, so I'm not going to hear that either. So that has really very little to do with the Washington state law. I mean, fair enough, I suppose. Likewise, defendants repeatedly assert that the thing is a criminal procedure statute that cannot turn the civil claim into a criminal one. In fact, the Washington expressly distinguishes between civil harassment claims under something and civil criminal claims under something else. Okay. Well, to figure out whether that's true or not, okay, so now I understand what they mean. So they didn't phrase it this way in the complaint, but I understand what they mean now. So, and also it's 2:30 in the morning, so give me a break. It's late. I'm doing this for you guys because I love you guys so much. But now I understand what they mean. So in the complaint to dismiss, or the motion to dismiss, they said that this harassment thing was a criminal law statute, and the operative law said that you couldn't turn it into a civil lawsuit. That was what KJ's lawyer said. So then Toddy comes back and says, well, actually there's two different statutes. So there's this statute and this statute, and we're actually suing over the one we can. So to figure out whether that's true or not, I actually have to dig into Washington state law, which I'm definitely not going to do right now. So, but we'll just take note that there's a bit of a dispute over this. So KJ's lawyer said, you're suing us on a criminal statute and you can't do that. And then Toddy interpreted that as saying, well, you don't have subject matter jurisdiction, which isn't quite the way I'd phrase it, but okay. So you don't have subject matter jurisdiction because you're trying to turn a criminal statute into a civil statute and you can't do that. So Toddy's response is, well, it's not really a criminal statute. It's really a civil statute because there's two different statutes. And given the relative quality of the legal writing between the two sides, I'm somewhat more inclined to believe Toddy's side than KJ's side because this seems to be more eloquently drafted so far. So we're just going to assume that Toddy's right and that Katie's lawyer is wrong. And yeah, no, she can sue over that. If there's a valid civil cause of action, she'd be able to file. So the only question is it a civil cause of action? And she says it's a civil cause of action. I'm like, okay, we'll go with that. It's a civil cause of action. Great, fine. All right. Am I going for 24-hour streaming? Maybe. All right, so let's see. We should deny the 12B1 because the inclusion of Doe defendants do not destroy diversity. This is probably true. It was a weak sauce argument. I said it was a weak sauce argument before. I said it was a weak sauce argument when I saw it in KJ's thing. So I already think it's I already thought it was a weak sauce argument for motion to dismiss. But we'll read about this for the Doe things. Generally, courts in Ninth Circuit hold that Doe defendants raise jurisdictional questions only when actual parties are substituted. Defendants' reliance on some other cases is misplaced. More recent Ninth Circuit decisions have called into question the rule announced in that based on a subsequent decision. So it sounds like there might be some dispute over exactly what the law is in the Ninth Circuit. Fun. Jurisdiction over defendants is proper in Washington based on the effects of their administrative conduct in Washington. When, as here, the motion to dismiss is based on written materials rather than evidentiary hearing, the plaintiff need only make a prima facie showing of jurisdictional facts to withstand the motion to dismiss. To satisfy this prima facie standard, a defendant need only demonstrate facts that, if true, would support jurisdiction. Fair enough. You only need to show that what you're saying, if it's true, we'll assume it's true for the purposes of this exercise. If it's true, that you'd have jurisdiction. Fair enough. Uncontroverted allegations of complaint must be taken as true. Yeah, pretty much. Unless they're absurd. You don't have to do that. But if they're not absurd, yeah. And factual disputes raised by affidavits must be resolved in the plaintiff's favor. The Ninth Circuit applies a 3-factor minimum context test to determine if the exercise of personal jurisdiction is appropriate. All right. So now we have to figure out whether or not we have personal jurisdiction over these people in this place. Okay. The non-resident defendant must purposefully direct his activities or consummate some transaction with the forum or resident thereof, or perform some act by which he purposefully avails himself of the privilege of conducting activities in the forum, thereby invoking the benefits and protections of law. Fair enough. The claim must be one that arises out of or relates to defendant's forum activities. Yeah, it's the thing that you did that caused the harm. So that's actually kind of important there. The thing that you did is the thing that caused the harm. So that purportedly would mean that I'm off the hook, thank God, in the Ninth Circuit, right? Because merely me pulling cases would not be enough, because me pulling cases isn't causing anyone harm, hopefully. So, so that actually is a bit of a problem for Toddy's theory of the case, because Toddy was saying how her pulling records and stuff might be a jurisdictional issue, and this seems to go the other way. It seems to suggest that unless it's related to what you did that caused the harm, that doesn't create jurisdiction. So you can pull all the records you want, it wouldn't create jurisdiction. So it seems then, therefore, that trying to pull all these records and trying to pull all these documents are not the basis of the complaint. The basis of the complaint is the many, many videos, not the pulling of the documents. So all that pulling of documents and stuff does not seem to create jurisdiction in the Ninth Circuit, which is good for me because it means I can continue my legal channel. Yay. So that's positive news. So the claim must arise out of or relate to the conduct activity. The exercise of jurisdiction must comport with fair play and substantial justice. It must be reasonable. Nice. The good stuff is in the declaration. Are you reading ahead? We haven't gone that far. We haven't gone to the declaration. We're on page 10 of a hypothetical 125. No reading ahead. It's bad. For the first part of the test, whether a claim sounds in tort. I never like that phrasing, claim sounds in tort. That's to say, if it's a tort. Is it a tort? which is any civil wrong not from contract, incidentally. If you want to know what a tort is, the easy definition is any civil wrong that is not based in contract. Claims, sounds, and torts. So fancy. Like the claims in this case, the Ninth Circuit generally employs the purposeful direction framework from Caldera, also known as the effects tax. Commission of an intentional act, expressly aimed at the foreign state, causing harm the defendant knows is likely to be suffered in the foreign state. Notably, the Ninth Circuit has expressly rejected the brunt of harm requirement relied upon by defendants in their motion to dismiss. Okay. In addition, where the claims all arise from the same common nucleus of operative facts and personal jurisdiction is established as to at least one claim, the courts will generally exercise personal jurisdiction for remaining claims. That's fair enough. That's fair enough. If you have jurisdiction for one claim, then we'll hear all the claims. That's an issue of judicial efficiency. I mean, the issue of jurisdiction is like fundamental fairness. And if it's fair to judge you for one thing, then we can bring in all the things. So yeah, that's very true. So we only need to find jurisdiction for one thing. Fair enough. Defendant has has sufficient context with Washington, confer personal jurisdiction. Unless you're making a videos is alleged to defame the subject of the videos. What do you mean, Jaws Med? What do you mean? I said that pulling the documents isn't enough. And you say unless I'm not following. You have to give me a break. It's 2:30 in the morning. But Joe's Med said, unless you're making of videos is alleged to defame the subjects of those videos. I don't know if that was responsive to our idea of me pulling the documents. The documents isn't what's creating the harm. The videos would be what's creating the harm, but not the documents. So my pulling of the documents alone would not be enough, was my argument. So I don't know if you're responding to what I was saying, but that's not what I was saying. Or maybe I'm missing the point. It is 2:30 in the morning. Here, defendants have sufficient context with Washington to confer personal jurisdiction over all of them, as claims in this case because contrary to Paulson's sworn statements. Hey, Rachel. And happy Christmas Eve to everybody, and happy Christmas to some of my brethren who in Australia or otherwise. To all my brethren in Australia, maybe you're having Christmas already. Maybe not yet, but getting close, probably. Yeah, no, it should be Christmas Day, actually, in Australia, isn't it, at this point? Anyways, happy Christmas, everybody. Okay. Defendants have sufficient context with Washington to confer personal jurisdiction over all of them as claims because of the contrary of Paulson's sworn statements. Defendants searched through and relied upon Washington sources for harassing and defaming stories. See, that's not going to work. That's not causal. In the stories, defendants suggested plaintiffs significant Washington connections. Defendants knew or should have known that such stories have viewership in Washington. Again, I don't like this. This argument can't be right because that would mean that they have jurisdiction everywhere, and that can't possibly be true, right? Because YouTube is everywhere. So, like, if the standard is knew or should have known the stories have viewership in Washington, like, I know or should know that my stories have viewership everywhere. Everywhere. And that means that they have jurisdiction over me everywhere? I hope that's not true. Still the 23rd in Alaska? That's true. It is still the 23rd in Alaska. Alaska holding on. Defendants publish, yeah. You know, you guys can do me a favor and get Emily's opinion on specifically this point, because I'd like to know what Emily thinks about this issue. Because if the idea is that you know or should know that your stories have viewership in Washington, Emily is a smart girl. Emily knows, or smart woman, I probably should say. Smart girl sounds insulting. It wasn't meant to be. I apologize. Emily is a smart woman, and she knows, for damn sure, and she should know, that her stories have viewership everywhere, especially with the popular channel she has. So I'd be interested to know what Emily thinks on this issue about, by making YouTube videos, am I suddenly purposely availing myself of everywhere? Is she purposely availing herself of everywhere? I'd be interested to hear what she has to say on that point. That'd be an interesting point of legal analysis. So hopefully she'll talk about that one. That'd be interesting to see what she says on that. Defendants published defamatory statements in Washington deriving income from publication when they knew that cover injury. Again, this is the same problem. This is the same problem Emily has, same problem I have, same problem Nick Ricada has, same problem like every YouTube channel in the history of time has. Or we're publishing statements in Washington. We're publishing statements everywhere. Deriving income from that? Yeah, we're deriving income from it. I mean, this is monetized. Please give me super chats. You know? So, yeah. Defendants also only argue the first prong of minimum context. Principal's direction is not satisfied. Defendants do not address either second or third prong. Defendants also do not, that which is probably true and probably a problem in drafting. So, like, could we have made a better argument? Probably. Defendant's primary argument against personal jurisdiction, defendants not engage in any conduct that connects the defense to Washington, expressly aiming prong. Defendant's secondary argument is that the brunt of harm was not incurred. Defendant's argument is that Halo's Nevada citizenship automatically precludes jurisdiction over defendants as to Halo's claims. Defendant also asserts that Toddy and James's allegations of domicile in the complaint are contradicted by the public statements. But defendants fail to demonstrate how Halo's domicile is relevant to inquiry of whether personal jurisdiction ever exists for defendants. Fair enough, those are indeed separate questions, right? Diversity jurisdiction is a different concept from personal jurisdiction. So, fair enough. Yeah, as to personal jurisdiction, fair enough. It wouldn't let you super chat? Did I forget to monetize this or something? No, monetization is on. It should work. All right. There's a super chat. Hello, Rachel. Thank you. $5. Happy holidays to you, Rachel. And then we get it on screen. Happy holidays. Yay. I love it when it works. Defense arguments against the court's exercise of jurisdiction fail for several reasons, not the least of which is because they rely on Paulson's misleading declaration as well as evidence submitted by defense attorney about which he lacks personal knowledge. In addition, defendants' arguments and reliance on non-defamation cases ignores the finding and analysis in the other cases. The Supreme Court's two seminal cases on personal jurisdiction and defamation cases were decided on the same day, which remain good law. $2.99 from Rachel. XOXO UK. XOXO to you as well. XO to XO to you as well. Can I explain the difference as you go? Oh, sure. I'm happy to explain the difference of anything I need to. So we're discussing the difference between personal jurisdiction and subject matter jurisdiction, right? Or diversity jurisdiction. Okay. All right. So let's try to do all that and discuss all that. Happy holidays from Fran. We love the unbiased sass. No problem. All right. So I'm going to try very hard to discuss the differences between subject matter jurisdiction, diversity jurisdiction, and personal jurisdiction. Okay. All right, so the term jurisdiction, in the broad sense, all the jurisdictions, refer to the authority of a court to hear the case, right? So you have to have jurisdiction to hear a case. All right, so that jurisdiction comes in a couple different varieties. First, there's subject matter jurisdiction, which is jurisdiction over the subject. That is the matter at hand. So why can this court hear this kind of case? It's because not all courts can hear all kinds of cases, right? Some courts hear criminal cases. Some courts hear civil cases. And even then, sometimes they split it up more. So not all courts hear all kinds of civil cases. For example, you might have heard of small claims court. Small claims court hears small claims, not large claims, for civil law. So subject matter jurisdiction is the concept that of can this court hear this kind of case? All right. So then we're in federal court. And so when we're asking for subject matter jurisdiction, that comes in two principal varieties. There's what's called there's either federal question jurisdiction or diversity jurisdiction. Federal question jurisdiction is the easier one. You have a federal question, which is to say you have a federal cause of action. You're suing under federal law. So a good example of that would be copyright. You're suing for copyright infringement. You might be able to sue for that under state law, but you definitely can sue for it under federal law because it's a federal cause of action. So if you want to, you can sue in federal court for copyright infringement because it is a federal cause of action. As opposed to, for example, I don't know, defamation would be the one at some point. And for that matter, most most kinds of harms are state law based. So I defamed you, or even I hit you, would be battery, right? So I hit you, that's battery. Unless there's something else going on, that's a state law issue. It's not a federal issue. Federal courts don't hear those cases, right? So one thing could be because it's a federal question, and there are lots of things that are not federal questions. The other reason that you are principally in federal court is civilly is if you have a diversity jurisdiction. So in diversity jurisdiction, all the people who are plaintiffs, you look at all the states that are plaintiffs. You look at all their states, whatever there are. It can be any number of states, and there can be more than one of the same state. So you look at the plaintiff side, and you look at all their states, and there can be more than one on that side that's the same. So you could have like 2 Californias, you could have 3 Californias, a Nevada, a Pennsylvania, whatever. On one side, you look at all the plaintiffs and all their states. And then you do the same thing on the defendant side. And then the question is, does any state appear on both sides? So you can have 5 Californias on one side, but if you have California on both sides, that's a no-go. You can't do that. So you have to have complete diversity of jurisdiction. There has to be complete separation of the parties. So to keep it easy, right, if a California resident is suing a Florida resident, right, that keeps it easy, right? Then you're in federal court as long as you're suing over more than $75,000 of value. So they don't do small stuff. They do relatively larger stuff. So it has to be at least $75,000 of value. So to recap, subject matter is, can I hear this subject? If I'm in federal court, that comes with 2 different main varieties. Federal question, I have a federal cause of action. I'm suing under federal law. Copyright infringement would be a good example. Or I'm suing under state law, but I have complete diversity of the parties, like California versus Florida. And it's at least $75,000. No, apologize. Not at least. More than $75,000 of value. I have to correct myself because I'd get that wrong on the bar exam if I said at least. It has to be more than. Okay. So that's subject matter jurisdiction, diversity jurisdiction, federal question jurisdiction we just covered. All right. So now dealing with personal jurisdiction. Personal jurisdiction applies only to the defendant, not to the plaintiff. That was the first time I beat my head against the wall. When we did that stream, that was the first time I beat my head against the wall because they wrote plaintiff, and what they meant to write was defendant. Remember when I beat my head against the wall? I'm sure you do. All right. So the question is, and this is, well, it would be true in civil and criminal law. It's just a lot easier to solve in criminal law than civil law. The basic question is it fair for this court to hear this case involving this defendant? So to keep it simple, if I've lived in Florida my entire life and never ventured out of the state, and suddenly I'm being sued in Rhode Island, like, it's not really fair to me because I've never been to Rhode Island. I have no affiliation with Rhode Island. Rhode Island has no business over me. So that would be an easy example, right? So I've lived in Florida my whole life. I've never done anything outside of Florida. I've never been anywhere, never done anything. And suddenly I'm being sued in Rhode Island. So it's like, well, the court doesn't have personal jurisdiction over me because I haven't done anything in Rhode Island. Whatever else I've done in my life, I haven't done it in Rhode Island, right? So an example of how this might come up to be, right? Suppose that I'm on my beach one day and some guy from Rhode Island decides he doesn't like the beaches of Rhode Island very much, so he'd like to visit the beaches of Florida. So he comes down to Florida, and because I'm a Florida man, I beat the shit out of him. And now he's sad about me beating the shit out of him, and he goes back to Rhode Island, and he sues me in Rhode Island. He can't do that. I beat the shit out of him in Florida. He can sue me in Florida, because that's where I beat the shit out of him. I also live in Florida, so that makes it easy. But if he wants to sue me in Rhode Island, it's like, no, that's not fair. I beat the shit out of you in Florida. Never been to Rhode Island. Don't know about Rhode Island. Why don't you come down to Florida and sue me? Jackass. So, that's an example of how that might pop up. So hopefully that was helpful. Even if I really beat the shit out of him a lot, so that's even if he incurred more than $75,000 in damages. So I beat the shit out of him so much that he went to the hospital and he incurred more than $75,000 worth of damages in this hospital, which, is not exactly outside the realm of all possibility. So let's go with that. So I really beat the crap out of this guy, and he suffered more than $75,000 in medical bills. And now he goes back to Rhode Island, and he wants to sue me in Rhode Island. It's like, no, you can't do that. You can sue me in Florida, but you can't sue me in Rhode Island. So there you go. Hopefully that was helpful to explain to everybody. Okay, great. Yeah. And someone asked, what if it's less than $75,000? Then sue me in state court. We were talking about federal court jurisdiction just now. So I might have jurisdiction somewhere else, not in federal court. Or a couple more super chats. $4.99 from Fran, or there was £2.99 from Rachel, gave me a thumbs up. $4.99 from Fran, said happy holidays, we love the unbiased sass. No problem. $5 from Jenny Rose. Thank you for staying up late and going with us. Merry Christmas. Merry Christmas to you. $6.99 of Canadian dollars from Michael. Thanks to you for being awake and going over this. Much appreciated. No problem. I'm the boss, $4.99 as a law nerd and motions brief paralegal. I appreciate your review and discussion in this response. Thank you. No problem. $4.99 from Shauna Lee. Thanks, Uncivil, for reading the documents for this late. No problem. And $5 from Melody Nolan. Thank you for doing it this hour. The law nerd is happy. Excellent. Fantastic. I'm happy that you're here. I am so happy that the 310 of you are currently here. That is awesome. I really appreciate it. Fantastic. Thank you. All right. Yeah. Well, where was I? Defendant's arguments against this court's exercise of jurisdiction fail for several reasons, not the least of which is because they rely on Paulson's misleading declaration as well as evidence submitted by defendant's attorney about which he lacks personal knowledge. In addition, defendant's arguments and reliance on non-defamation cases ignore findings and analysis in 2 Supreme Court cases. Excuse me. In Chaldeer, the plaintiff's claims against defendant, writer, and editor were based on an article appearing in one issue of a weekly newspaper with national circulation. The article was written and edited in Florida by defendants, discussed the California activities of a California resident whose work was based in California, and impugned the professional reputation of that resident by alleging that she drank so heavily as to prevent her from fulfilling her professional obligations. Although the writing and editing of the article, most defendants relied upon California sources. Only the writer actually contacted California sources. Okay. The Supreme Court held the forum-related conduct of both writer and editor of the defamatory story constitute express aiming at the forum by each defendant and satisfy minimum context. In that example, probably yes. So maybe that's kind of where they're going in that analysis, like, because we're targeting this specifically about Toddy. So maybe. There might be an idea in there somewhere that might work. Okay. In Walden, Supreme Court reiterated that in Chaldeer, the special nature of tort of defamation itself, together with the injury to plaintiff. And by the way, incidentally, if you have questions along the way, just put my name, with the @ symbol so it's an orange, so that I can see if there's a question. And I'll try to answer questions along the way, because I am here to be a legal educator, and I want to be the best legal educator I can be. And my only questions are, keep it to the, this is more to Matt, who I don't think is in the chat right now. But if you are, keep the topic on point. Please don't ask me insane hypotheticals about what happens if, incredibly unlikely things happen, because it hurts me. It hurts my soul. In Kenton, the Supreme Court found that while the plaintiff's residence in the forum state is relevant to jurisdictional inquiry, there's no justification for restricting liable actions to plaintiff's home forum, and lack of residence in the forum will not defeat jurisdiction. The court expressly noted in reaching its holding it did not rely on the very minimal contact the plaintiff had to the forum. The Supreme Court's analysis regarding the nature of the defamation tort and harm is instructive. The tort of libel is generally held to occur wherever the offending material is circulated. So we might all be totally screwed when it comes to YouTube. The reputation of the liable victim may suffer harm even in a state which has heretofore remained anonymous. The communication of libel may create a negative reputation among residents of a jurisdiction where plaintiff's previous reputation was, however small, at least unblemished. Unlike Chaldeer, where defendants were not the owners of the newspaper and did not have an economic interest in the publication, circulation newspaper. In this case, the defendant was the magazine itself and profited from the circulation. The Supreme Court found that even a small portion of the total number of defamatory issues were circulated. Repeated circulation of the magazine in a form was sufficient to establish personal jurisdiction. Okay. Yeah, I don't know how that applies to YouTube, though. I mean, these are situations that do not. These are from an analog era and a digital realm, and I don't know how that applies to YouTube, because you're dealing with a newspaper and the publishers of a newspaper who are distributing it in a lot of different states. And so that's maybe one thing, but this video will live on forever and be rewatched by many people. And so is that repeated circulation? And now am I suddenly being subject? Am I going to be hauled before a court in New Zealand? Well, if they pay for my travel, maybe that won't be so bad, because New Zealand sounds like a place I'd like to go. But, you know, I'm interested to see what Emily thinks on the YouTube implications of these kinds of stuff. This is stuff I don't think about a lot because I don't have this problem. The reason I don't have this problem, by the way, in my life, by the way, is because all I deal with is federal question. I'm a patent lawyer. That's exclusively federal. There is a little bit of state copyright still floating around, a little bit in New York, and there's a little bit of state trademark law still floating around, but there is no state patent law. There never has been. Patent law is exclusively federal. It's a federal question. So if you're wondering why I don't know a lot about this, it's because I don't have to deal with it ever. It's easy for me. It's always federal. And I always know where every appeal is going to go. It's always going to go to the Court of Appeals for the Federal Circuit. Every time. It's great. It's easy. I know where every appeal is going. Forever. Yay. So I don't worry about that too much. Hello, Rich. How are you doing today? Man. I believe Toddy will win the lawsuit. Hard to tell. Right now things are not looking as good for KJ as they should be, in my opinion, because I think KJ missed some outstandingly good opportunities, especially in the defamation. We haven't gone through the jurisdiction stuff, where I'm less an expert, because I don't have to think about it ever. But KJ looks, without a crystal ball, has some pretty interesting defenses on the defamation, which is the core of Toddy's case. She has some interesting defenses when it comes to the underlying truth of it, and the public figure stuff is really going to help. So, but of course, KJ didn't actually move to dismiss any of those things, which was the second reason I beat my head against the wall last time. Because that would have been really helpful to mention all of those things. But if KJ ever gets her act together, she has some really interesting defenses. And, you know, if she can do it, that would be really helpful. The jurisdiction stuff, not my area of expertise. But, you know, the defamation stuff, a little bit more confident. $2.99 from Rich. Let's get this drama started. We are getting the drama started all day long. Yeah, no problem. I'm Mr. Fox becomes a supporter. Thanks very much. Similar to the actions of the writer and editor, the defendant's conduct meets the express aiming requirements of the effect test because they searched through and relied upon Washington sources as part of their research. Additionally, like I don't think that's going to work. The research elements, I don't think that works. That's not the publication. That's a little bit thin. Additionally, like the defamatory article in Caldera, the defamatory content in this matter discuss and reference Washington activities and connections which are particularly appealed to Washington viewers. Defendant first announced their intention to expose Toddy and her harm, reputation, and Halo's business interests. Prior to and after this announcement, Toddy and her immediate family in Washington, they thoroughly investigated them. Yeah. I like how Uncivil's first video is like, who is Toddy? What is it without a crystal ball? Why is there so much tea? Yeah. Yeah. As you know, I'm pot committed at this point. That's basically what's going on. I'm pot committed for you. From the beginning, defendants repeatedly claimed to know everything there was to know about plaintiffs and their business because they research everything and everywhere, which sounds suspiciously good for the defamation claims, including Toddy and James's birth certificates, financial records, and business records, as well as Toddy's entire Washington-based family. It's a little creepy. In fact, the same May 2019 video referenced above, defendants flippantly questioned where Toddy's father was in the mafia because they didn't find any employment records for him despite searching every Washington-based database available to defendants. Well, if they really said it flippantly, that's actually not helpful to you, Toddy. Because if you're describing it as flippant, that suggests that they're not really saying it seriously. And if it's not seriously and it's meant to be understood non-seriously, it's meant to be understood hyperbole, that's not defamation, right? They're just saying it flippantly. So the very fact you described it as flippantly is actually not helpful. From the very first defamatory and harassing publication, defendant spoke about how Toddy grew up in Washington and how she's just a failed actress from Washington. I don't know. She has 9 million subscribers on her YouTube. She's doing something right. The idea defendants completely circumvented Washington's sources in their research of Toddy, her husband, other family members is wholly implausible, especially since defendant's own statements contradict that statement. This is all sounding suspiciously like we did a lot of work to reach our opinions, this is steering into the jurisdictional skid, although I don't know successfully, because again, I'm not sure that this research really works, and if it is, I have potential legal problems. Please help me, Emily, please help. I don't know that I want this much liability in my life. Because I downloaded this from Pacer, I suddenly have jurisdiction. I downloaded this from Pacer, I downloaded this from the Washington court. They have jurisdiction over me now because I downloaded this? I hope the answer is that no. Anyway, where was I? Yeah. But they're steering into they're making the case for jurisdiction, but they're also kind of defeating themselves on the defamation. Because the whole thing about defamation, especially if you're into public figure status, is you need the willful blindness, right? You need malice, which means willful blindness. It means you have malice to the truth, right? But if you're doing all this research and all this evidence, it's like, how can you possibly be willfully blind? It's like, I looked at everything. I did an incredibly deep dive. How willfully blind can I possibly be? So we're setting up the jurisdiction, although I'm not sure it works, but we're kind of defeating ourselves on the back end of the defamation, because, yeah, I don't know, that's a problem. Chat says it wasn't flippant, it was a serious claim. Well, chat says it wasn't flippant, but Toddy says it was flippant. Toddy beats chat, guys. I'm sorry to tell you, but Toddy beats chat because it's her complaint. So, you know who beats chat? Toddy beats chat. If Toddy says the defendant's flippantly questioned, then that's what she says. That's her argument. So you guys may not think it's flippant, but Toddy apparently thinks it's flippant. So, that's what she said. She said it's flippant. So, therefore, it's not serious. So, therefore, read the words on the page, man. From the very first defamatory and harassing publication, defendant spoke about how Toddy grew up in Washington and failed actress and all the rest of it. Likewise, defendant's assertions she did not know Toddy and James were living in Washington is patently false. In the June 2nd, 2019 video entitled The Background, Toddy and James Don't Want You to Know, defendants indicate they knew their current address. That doesn't mean they knew that's where they lived. See, that's two different things. They assert they didn't know where Toddy lived. Then they gave their address, which may or may not be where they live. It's not exactly the same thing. Defendants indicate they knew their home address, but they weren't going to reveal it. They then showed a copy of Halo's business information. Question is, how long can they tie Katie up in motions back and forth? A while. Yeah. I assume the next thing is an answer and maybe some counterclaims. That's probably the next thing after this. Even more revealing is the fact that defendants expressly redacted their street and city proportion of Toddy's address before showing to viewers. Meaning defendants had personal and physical interaction with the address and cannot claim to have seen it. Yeah, well, it doesn't mean that they knew that they lived there. In addition, Nevada's Secretary of State records showed another business of Toddy and James. Toddy Halo was a managing member of Halo, and Washington address was different from Toddy's and James's Washington address. Yeah, the business has a different address, so what? Who cares? Toddy's Halo is one of 3 Washington corporations owned by Toddy and James. All were incorporated in Washington, and their business information was publicly available. At the time of first defamatory and harassing publication, defendant knew all 3 plaintiffs had significant Washington connections and business activities. Given defendant's goal of learning everything there was to know about Toddy and a concerted effort to harm her, or do her due diligence, I would say if I'm Katie's lawyer, which apparently I am or something, according to some of the chat, it is impossible that by June the 2nd, defendants did not know about Toddy and James's Washington business activities through Toddy James and Toddy Halo. We have not got into defamation yet. We're still well deep in jurisdiction. We're on page 16 of 27, and we're still deep in jurisdiction. We've not gone to other things yet. Something I don't think about because it doesn't come up to my job. Jurisdictions for me is easy. Easy. So I don't think about it very much. What am I doing up Viden? I'm doing tea Viden, or Viden. What do you mean? What am I doing up? I'm doing some tea hour. I'm talking tea with the chat. The chat's here to support me in tea hour. It's very nice. So far, we're doing good. The defendants expressly end their conduct at Washington Forum because the defendants circulated their defamatory conduct to viewers in Washington and derived income from their content in Washington. Thin. Defendant even asked for followers, subscribers, and viewers, some of whom they know to be located in Washington, to donate money for the cost of research and obtain records to expose plans. Well, now I'm really screwed. Now I'm just totally fucked. I am completely and totally fucked now as a YouTube person because I ask for followers, subscribers, and viewers all the time. And thanks to all you guys who told me all the states that you live in and countries you live in, now because I've asked you, and I will ask you again, to please follow me, please subscribe me, please like me, give me your super chats, all that stuff. Yeah, because I now know that you're located in Ohio and Canada and Alaska and Australia and Scotland and all the other places. Apparently, because I've asked for that, now the entire goddamn world has jurisdiction over me. I'm waiting to be sued in Japan as we speak. I'd really like to hear what Emily has to say about this and her analysis on this. It'd be interesting to see if she has a more informed opinion on me. Now, I don't know, and I don't say this to belittle her in any way, I don't know if she knows more about this particular field than me than not, because as a former prosecutor, she also didn't have to worry about jurisdiction very much because the crime was committed in her turf. So it was pretty easy. It's like, well, the crime was committed here. That's the jurisdiction. Pretty easy. So I don't know that she spent a lot of time thinking about it, but maybe she knows more about it on civil law than me. So we'll find out because I'd be interested to think what she thinks. If we're all, if Emily, are you and I totally hosed? Are we fucked? Are we fucked in all the places? Did we fuck ourselves? Please let me know. Yeah. South Carolina, Australia. Defendant's argument regarding brunt of harm also failed. First, the Ninth Circuit, relying on Keaton, expressly rejected any requirement brunt of harm from defamation be felt in the forum. Secondly, as both Keaton and Walton courts note, during the nature of defamation itself, a party is harmed wherever defamatory material is published with a third person, regardless of the party's residency. The evidence before this court demonstrates the defendant's defamatory conduct was published to and viewed by Washington residents. The evidence also demonstrates that Halo's reputation was injured in view of the Washington community, and Halo lost Washington customers due to defamatory statements. Likewise, the evidence shows that Toddy and James' reputation in Washington were harmed by defendants' defamatory content, and Toddy and James experienced both emotional distress as a result of the defamation. Yeah, I'm not sure about that. Will I score at the end of jurisdiction? Sure, I will. I'll give a best opinion as I got when I get to the end. Further, contrary to defendant's arguments, Halo Nevada residency does not preclude the court from exercising personal jurisdiction. Court considers plaintiff residence in the forum as a factor supporting jurisdiction, but neither domicile nor residency is a requirement. That's fair. This is especially true in defamation cases where plaintiff is harmed wherever the statements are published. Like the non-resident in Keaton, Halo's Nevada location is immaterial to jurisdiction inquiry because defendant's own formulated context satisfies it. Fair enough. If true, fair enough. Yeah, that would follow. That factor is irrelevant. Yeah, that factor is irrelevant one way or another. That's true. Similarly, Toddy and Jamie's domicile cannot preclude the exercise of personal jurisdiction over defendants. unless it was the same as KJ's, which is not. So, yeah. Defendant's contacts with Washington satisfy all prongs. In addition, the second prong is also met because there's no dispute arises with contacts out of forum because the first two prongs are met. Defendant bears the burden of presenting a compelling case that the presence of other considerations will render jurisdiction unreasonable, which they failed to do. All right, so I think we've come to the end of jurisdiction. So, in the interest of scoring this, it feels weak. I'm not. I mean, I admit weaknesses I have because I think that's important. I think it's important as a legal communicator to admit when I'm weak in my opinion and weak in my knowledge base. And I read this and I'm like, yeah, I'm weak here. So I mean, my best opinion is it seems weak. It seems a little bit thin. Like if personal jurisdiction were clear, I could tell that. But this is like thin. So the question is it enough, even though it's thin? And I'm having trouble giving a firm answer to that question, and I apologize, but I think it's important to be humble and admit when I don't know something. So that way you will not be misled. I think that's a plus. But it seems a little thin. It seems a little thin that, just because she did a whole bunch of research and pulling cases from Washington or pulling documents from Washington, which I do all the time, not necessarily from Washington, but from other places, just because she pulled a whole bunch of documents and just because she acknowledged that someone in chat was from Washington one time, and just because she publishes a video, which is published in Washington, but it's published everywhere, and just because she asks for likes and subscribes and super chats from people, including people she knows to be in Washington, is that enough to give jurisdiction in Washington? The problem is, if the answer to that question is yes, then it implies that personal jurisdiction exists everywhere. That's the fundamental problem. So if the answer to that question is yes, then why is it not yes for like all the places? And then maybe the answer is it is yes for all the places, which is a bit of a scary conclusion if that's the right answer. So it was a little bit different in the case of the newspaper because they're printing physical things, right? The newspaper's printing physical things and shipping them to physical places with physical distribution, right? So they're in control of that and where it goes and who's seeing it when, because they're in control of which newsstands get it in order to distribute it and so forth and so on. So that's a little bit more understandable in the case of a newspaper. In the case of YouTube, it's like, okay, I'm not necessarily in control of who sees this or when or how. I publish it on the internet and anyone can see it at any time in any jurisdiction. And I know full well that like everyone can see it. And I've got 18,000 subscribers, which isn't enough, which isn't a lot in the grand scheme, but 18,000 subscribers, it's probably reasonable to assume that I have at least one subscriber in every single state. I mean, that seems probable. So like the fact that I can guess that I have and if it's true for me, it's even more true for Emily. So like, are we all now, the thing is like, there's nothing special about Washington here. So if it exists in Washington, then why doesn't it exist everywhere? And if it exists everywhere, then what's left of personal jurisdiction in the internet age? And so that's my sort of analysis. So I'm kind of hoping that something more is needed here, and this is not enough, because if this is enough, we're all completely fucked. I don't want to be sued in Alaska. So, jurisdiction seems thin. So, with a somewhat weakened opinion, I'm going to tentatively score the jurisdiction issue for KJ because it seems thin. And maybe Emily will have a better and more confident analysis. So I will happily defer to Emily if she has a more confident opinion than mine. Some opinions I'm more confident in than others. This is not one of those times. Okay, let's read some more. I'd be able to tell if it was there, for sure. Like, if it was there, I can tell for sure if it's there, but this is weak. I'm like, I don't know if it's enough. I kind of hope it's not, because it implies a whole bunch of things I'm not happy about necessarily. All right, so let's read about the 12B6, which is more interesting, and I'm going to have a more informed opinion about, because this is a motion to dismiss for failure to state a claim. So in considering the motion to dismiss for failure to state a claim, the court must assume all well-pleaded, non-conclusory factual allegations are true unless they're insane, and the court will determine whether such facts plausibly arise to an entitlement for relief. A claim for relief is plausible on its face when the fact pleads factual content that allows the court to draw a reasonable inference defendant is liable from the misconduct. To cross the threshold from conceivable to plausible, factual allegations must be sufficient to raise the entitlement relief above the speculative level. The standard asks for more than sheer possibility, but it's not akin to probability. Fair enough. All right, so let's think about the extreme and emotional conduct. Defendants assert plaintiffs fail to allege sufficient outrageous conduct as to IIED, which, incidentally, you would expect you would just expect it from the start, the defense to win, because IIED is really, really hard. It's really hard to get an IIED claim. Defense arguments, however, fail to acknowledge that IIED claim incorporates all the preceding factual complaint. No one cares. Imputing criminal conduct, defendant has a history of defrauding lenders, engaging in fraud and money laundering. Moreover, the 19-month campaign of harassment towards Toddy and James and the onslaught of internet postings harassing and defaming with the intent of harming their business and causing distress also demonstrates the outrageous conduct of defendants. No. The key word in intentional infliction of emotional distress is intentional. You have to intend the distress. That's really hard. And I don't think this works. For negligence infliction, maybe. Intentional, probably not. Someone asked, at the time KJ... Oh, Christina Saka says, new subscriber to Uncivil Law. I'm attorney licensed practice law in California. We lawyers never sleep. Well, thank you very much, Christina, for being here. I'm happy to have you as a member. It's awesome to have more lawyers here. That's great. Myra M says, at the time KJ was part of Pathos, his blog where she's a lawyer. Does that count as publication? If it does that cover jurisdiction? No, because the way the Ninth Circuit phrased the jurisdictional standard, if I read it correctly, the harm has to flow from the things that created the jurisdiction. So unless KJ did things in the Pathos that created the harm, then no. And that isn't the allegation, as best as I understand it. The allegation, as best as I understand it, is it was the YouTube videos that created the harm, not what she did in Pathos. So the way I understand the three-part standard from the Ninth Circuit, which we read earlier, is that the thing that is creating the jurisdiction is the thing that has to create the harm or be proximately causal or be close enough to create the harm. And so unless they were alleging the articles in Pathos caused harm, which they're not, then I think it's irrelevant, as best I can determine. So I don't think that creates jurisdiction as I understand the three-part standard. But thank you for the question. Yeah. Someone said the Pathos article was discussed in the initial filing. Maybe. But I don't think it was mentioned in this response. So if so, I've forgotten about it, and so probably has the court for that matter, but we'll press on. In addition, defendants were not innocently reporting from public records. They were falsely imputing serious criminal conduct in a very public manner. They knew their statements were false. Did they, though? Defendants' conduct is not a certain degree of rough language, unkindness, and lack of consideration. IIED is really hard. Please leave the footnote of the last page. Says she owned a home but didn't live in LA ever. The evidence submitted to the court demonstrates that Toddy and James were domiciled in Washington at the time of the defamatory conduct. They signed an 18-month lease, paid taxes, they owned Washington, their personal business accounts. Also, after they purchased a home in California, they did not live in Los Angeles or ever stay in the house. Noted. I think we covered that before in the text of the thing, but fair enough. Although plaintiffs have brought their claims under Washington law, defendants explicitly rely on California law to argue their allegations and the plaintiff failed to state a claim. Yes, Emily did take note of that, and she was also bewildered by that fact. Generally, when plaintiffs incur severe emotional distress, is a fact of question for the jury. IIEDs are really hard. In contrast to California cases, in evaluating the viability of IIED, Washington courts focus more on the outrageousness of the conduct around specific symptoms of the emotional distress alleged. Fair enough. Moreover, plaintiffs have alleged sufficient facts to create reasonable inference that defendant's defamation and harassing conduct is ongoing, continuing to cause plaintiffs to incur severe emotional distress caused in the complaint. In addition, while embarrassment or humiliation is insufficient, plaintiffs have alleged to show severe emotional distress. Furthermore, unlike California case cited by defendants, plaintiffs have not relied upon conclusory assertion of emotional distress, but have alleged specific emotional distress, including despair, nausea, lack of sleep, and self-helplessness. Washington courts have found similar symptoms as those alleged as IIED. Plaintiff's IIED is plausible. IIEDs are really hard. Really hard. So, if I were a betting man, I have to say tentatively, I'd expect it to be dismissed. IID is really, really hard. Really hard. And yeah, I don't think is enough. IID is really hard. Defendants' reliance on California law and Ninth Circuit dissenting opinion does not show defendants are entitled to dismissal of negligent infliction. The complaint alleges severe emotional distress sufficient to show a claim. As the case law shows, emotional distress, objective symptomology need only be susceptible to medical diagnosis and then proved. The argument appears to be that plaintiffs submit medical proof of distress. The notice pleading standard rule has no such requirement. They were citing some case law for that proposition. It's not that you have to submit proof of emotional distress. That's not quite what they were saying. They said that you have to allege a medically diagnosable condition, which I don't believe you did, as best as I can determine. Not like one that I'd recognize from like the the diagnostic manual or something, not from the DSM, and like in sort of a diagnostic condition. So it's not you have to prove it, you have to allege it. And I'm not sure you ever did that. So it wasn't that they said you have to submit proof. They said that you had to allege a specific medical condition. And you try to address this in the IID claim by saying that they didn't need to do that. But is it different for negligence, infliction, emotional distress? You do need to do that in Washington State specifically, because I'm trying to remember the motion to dismiss. And I think they did cite Washington's specific law. It said you have to actually plead a specific diagnosable condition, which you didn't quite do. So they might be right. So the pleading standard doesn't exactly say it, yeah, but the relevant tort does require it. And if you didn't mention it, it might be enough. So that might be a very, very technical aspect of the law, which we'd actually have to really get into. But if they're right the way that KJ argued it, if KJ's right, then that might be a winnable argument on that basis alone. It's a very technical thing, but then again, law's often technical. Plaintiffs have alleged they incurred medically diagnosable disorder, depression and anxiety. And then they cite a case from Washington. It's a Washington district court, it looks like, which is not nothing, but, not as good as the Court of Appeals, but we'll take what we can get. Finding that symptoms of depression and anxiety were sufficient to constitute a diagnosable disorder. So this citation, this is Washington state law, though. Snyder, Washington 2nd. What is that? Is that a Court of Appeals case in Washington or whatever? Let me Google real fast and figure out if I can figure out what that is. Hold on. Let's see. Is this Supreme Court of Washington? I think it might be Supreme Court of Washington. Mm-hmm. Did they give me a pin site? It did. 233, 254. So this is from the court. This is from the court decision that's cited in 120. So I'm going to read the citation. This court has held. This is the Washington Supreme Court talking. Washington State Supreme Court talking. This court has held that an objective symptoms requirement is satisfied if symptoms constitute a diagnosable emotional disorder. In the case before us, the record contains undisputed evidence that Snyder exhibited symptoms of anxiety, depression, and PTSD. Okay, I'm sold. I'm sold. Symptoms of depression and anxiety are sufficient, according to the Washington Supreme Court. I'm sold. That's a fair reading of the Washington Supreme Court opinion. See what we did there? We did a citation check and we did an analysis of a citation in real time. How cool is that, right? Oh, man. This is the lengths I go to. It's like, let's read that and see if that actually makes sense. And then I read it. I'm like, yeah, that makes sense. I'm sold. Great. Fantastic. That's enough. Okay. So in that case, because they did allege anxiety and they did allege depression, and that apparently qualifies under according to the Washington State Supreme Court. And as I've pointed out many times, and I'll continue to point out again, the federal courts must take the state law as a given. The federal courts, including the U.S. Supreme Court, cannot and may not ever challenge a state as to its own state law. The federal courts must, including the U.S. Supreme Court, must take the state law as a given. So, if the Washington State Supreme Court says that anxiety and depression are sufficient for a negligent infliction of emotional distress on Washington State, that is legally binding, including on the U.S. Supreme Court, as I have noted many times recently as we've been covering election cases and arguing with other lawyers about this. And yeah. Sometimes. So that looks like a promising thing for Toddy. So that's one. Now, see, this is also like why I was so distressed myself by failure to bring up the defamation cause of action, because I thought the defamation cause of action was so central. And like I could see if that defamation cause got completely destroyed, I could see it all falling away. Like I think this argument might not work if the defamation cause died. It works in isolation, but I'm not sure it works if the defamation cause dies. Because it's one of those things that like strong arguments are undermined by weak arguments and so forth. And the defamation was so central to the cause of action. It was the heart of the case. And if that heart of the case gets stripped out, I'm not sure a court cares very much to keep reading. But because KJ and her lawyer, in their infinite wisdom, decided not to move to dismiss the defamation, where she had really, really good arguments, and she decided not to do that, I think her odds are not looking as good as they could have been. If KJ and her lawyer had decided to go a different direction and actually move to dismiss the defamation like, a sane person and come up with a really strong cause of action. And then they obliterated that, which I think they had the opportunity to do. And then Toddy came along with, but I still have this negligent infliction of emotional distress claim. I could see a court not caring. However, because they decided not to do that, and because we are just going to pretend the defamation thing exists because we don't want to argue against it, even though we have really good arguments, and so the court doesn't have the punch in the gut of having the floor swept out from under you because the defamation cause of action was completely obliterated, and now they're looking at you like you have no hope, and they just want to put the wounded deer down. But because that never happened, all they can see is the argument, which would have been weak if it had been followed by the complete destruction. But because complete destruction never happened, now it suddenly looks a lot stronger than it would have. So now Toddy looks a lot better than she really probably should have been looking, because KJ and her lawyer, in their infinite wisdom, decided never to move to dismiss the defamation. Okay. Defendants' arguments fail to acknowledge the incorporation of the preceding factual allegation, including the fact defendants made their livelihood on YouTube, and the focus of their content is gossip or tea about other people. The number of defamatory videos defendant made about Toddy is also relevant as the allegation that defendant had similarly targeted other people. Moreover, defendants' arguments misstate the public interest requirements under the CPA. Plaintiffs do not have to prove another person has been threatened. They have to prove defendants' unfair disruptive could have injured another person. Sure, whatever. That's fine. Here are the complaints in the complaint. Established defendant had monetized videos, approximately 135,000 videos, on which they regularly post videos. Defendant's topics include drama or tea, gossip. They have a pattern of practice of degrading, harassing, and defaming others without bothering to verify their statements. And defendants were posting the statements on the same day they're filed. Sure, why not? I mean, since we're not going to argue the defamation cause of action, sure, why the hell not? Who cares? I am not using a green screen right now, no, at the moment. This is actually my apartment. But thank you for asking. Is this because you want me to beat my head against the wall? I'd beat my head against the wall, but it's 3:30 in the morning, and I don't want to bother my neighbors. So out of courtesy to my neighbors, I will refrain from beating my head against the wall. But know that I'm beating my head against the wall in my heart. First, defendants erroneously assert testimony under oath regarding the harassment is a requirement at this stage. To the contrary, sworn testimony is not necessary until the court is deciding whether to grant a petition for order of protection. Here, the issue of the petition for order of protection has not been submitted. Moreover, because the First Amendment limitations, the defamation, and civil harassments are entwined such that civil harassment cannot be decided without first deciding whether defamatory, which we never moved to dismiss for some reason. Okay. Secondly, defendants speciously argue that the harassing content of creating at least 40 videos and more than 100 internet posts with defamatory statements over a course of 19 months is somehow not directed at Toddy and James. Is that what they said? Whatever, I'm not going to read it. Are they saying their own complaint? Yeah, they are. That's not right. That's a mistake. That's got to be a mistake. Yeah, it's got to be a mistake. In case you're wondering what the mistake I'm spotting here is, here's where it is. It says, second, defendants speciously argue the harassing conduct of creating at least 40 videos and more than 100 internet posts with defamatory statements about plaintiffs over the course of 19 months is somehow not directed at Toddy and James. So they're saying defendants are arguing something. You see that? Defendants argue their conduct, right? So this is defendants' arguments. And then they have a footnote to 130. If you go to footnote 130, it says complaint. But the complaint was written by Toddy. She's the one that filed the lawsuit. She's the plaintiff. So she said the defendants made an argument, and then in their footnote, they cite their own complaints, which isn't what the defendant said. It's what the plaintiff said. So this is a mistake. This is a mistake. We spotted an error. We spotted an error. Defendant's argument is nonsensical and contrary to Washington law. The code states the state legislative intent finds the serious personal harassment through repeated invasions of privacy by acts and words showing a pattern of harassment. Contact between harasser and harassed person is not a necessary component. And the definition of course of conduct means harassment takes a form of any communication, contact, or conduct which does not preclude internet postings. Of course it wouldn't. Additional person or jurisdiction expressly includes indirect communication, such as posting an electronic medium that's generally available. I guess it's possible. Moreover, the Western District of Washington previously held defamatory statements posted on the internet meet the definition of course of contact and unlawful harassment when the definitions were fixed firm by the NITE Circuit. In certain contexts, they can be, but you don't want to go to the end of the page because then you don't make sense. Defendant's interpretation of statute would exclude a vast swath of harassing conduct. Third, in a similar argument, defendants erroneously assert there are insufficient factual allegations regarding continuing purpose. However, complaint alleged ample facts stated in the goal of exposing plaintiffs as well as her persistent actions and making numerous defamatory statements on social media over the plaintiffs over the course of 19 months. I apologize, I'm beginning to slip over my words a little bit, but I'm tired. I'm doing the best I can. But I will try to pump my energy so that I don't make as many mistakes as reading. For example, the complaint specifically alleges Paulson has openly stated on her various platforms she will not stop going after plaintiffs until she otherwise openly dared plaintiffs to sue them, so Paulson can misuse discovery process to inflict more damage. Similarly, the complaint states defendants state publicly they intend to target Toddy, her family or business, and to do an expose on Toddy as retribution. Sufficient facts are sufficient to establish both targeting Toddy and James and knowing and willful conduct and continuity of purpose elements under the relevant law. Plaintiffs have alleged civil harassment. Sounds plausible. Sounds plausible. Yeah, sounds plausible. Okay. The court should deny defendants 12b7 to join. There's a three-part inquiry which defendants have failed to address. True, that would have been helpful. If you actually discussed the law at some point, that would have been nice. They failed to prove their burden. However, even if defendants had attempted to meet their burden, they could not because the action should be dismissed for not joining. They could not prove the action should be dismissed for not joining Dawson and Starr because the court may accord complete relief absent joinder. Yeah, that sounds plausible. Plaintiffs seek monetary damages against defendant. Defendants do not assert plaintiffs' request for relief requires any injunction of release against Dawson and Starr. Fair enough. Moreover, the basis of claims in this case are numerous defamatory statements made by defendants, not Dawson and Starr. Fair. Defendants acknowledge Dawson and Starr's conduct as separate and unrelated. Seems right. An absent party need not be joined simply because they might be provided to provide contributory or indemnity for damages. Okay, very good. Yeah, that's completely right. So this last sentence we'll spend a little bit of time on because we can learn something in law education world. Okay, so we'll read this last sentence and then we'll explain it a little bit because I think it's worthy of spending a little time on. Okay, so an absent party need not be joined simply because it may be required to prove contribution or indemnity for damages. Okay, so let's talk a little bit about what that means because it's actually kind of important, or it's actually notable. I don't know how important it is, but it's notable. All right, so indemnification is what an insurance company does. And what you do basically when you indemnify someone, you basically say that you're going to pay for their damage. You're going to pay for damages. That's indemnity, right? I'm going to pay if you're harmed. That's insurance, basically, is indemnity. And you offer it a lot. It's like, I'm going to make you whole if you get harmed. And a lot of contracts have it for a lot of different things, indemnity provisions, right? So number one is the idea is some of these people will be responsible in indemnity. They have pledged or they have a contractual promise to pay for damages, right? So that's idea number one. Contribution is also another idea. So the idea of contribution is a whole bunch of people caused harm, and I can sue one of the people instead of all of them. And if I get a judgment against one of them, then they can then turn around and sue the other people who also caused the damage for contribution to the damage. So the way this would most frequently come up is for like a big pocket. That'd be the time it would most frequently come up. So let's say that we have a whole bunch of people I could theoretically sue. And let's assume that one of them is particularly well off. And, you know, my cause of action is no better or no worse against any of them in particular. And so I'm going to go after the big pocket. And so I win. So I win $1 million damages against the big pocket. All right. But that doesn't necessarily mean the big pocket is responsible for $1 million. It means the defendants, in plural, are responsible for the $1 million, to which this defendant is a part. He's a contributor. He's contributed to the damages. Right. So the total amount of damages to me are $1 million. He's the only person here. So we'll get him for the $1 million. Now, what he can do is turn around and sue the other people, right? Because he's not responsible for the $1 million. He's responsible for only as much as he did. So this would be the equivalent. This would be the equivalent of someone suing you. Let's say that you and let me create a hypothetical that makes sense. What would be a hypothetical that makes sense that would be easily understandable? I mean, an automobile accident would be the easiest one, but insurance companies usually come into play. But I guess they can sue each other, so that makes sense. So let's do an automobile accident. A chain automobile accident, right? So it's a complicated automobile accident. All right, so there's an automobile accident in which let's say it's me. I'm parked. So let's say that the hypothetical is such that I am blameless in this situation. We'll make our lives easier. I am blameless. I am completely righteous in my automobile driving. Make it easy. I am blameless and righteous in my driving. All right. So then, like, let's say that someone hits me and causes damage, right? So that's easy enough. I can sue them. Let's say they hit me, and then the guy behind them hits them, and then that causes more damage to me, right? So now, like, there's more than one person who's caused damage in some sort of chain, right? So I can sue the guy who hit me, right? I can sue him and say, well, this is the amount of damage to my car, and I need you to pay for all of it. But he can say, well, I'm not responsible for all of it. I'm going to be like, well, that's not my problem. That's your problem, right? This is the amount of damage to my car. This is how much I'm owed. And because I'm righteous, right, I'm going to get my damages. But he can turn around and he can sue the guy behind him and be like, well, actually, it wasn't me who caused all that damage. It was also you who caused some of that damage. And so I want the contribution. I want your share of it and get it after you. Now, normally in like an automobile situation, the insurance companies just sue each other, and this all happens behind the scenes. So you don't have to worry about it in the real life, but this is contribution, right? So the idea here is just because other people, this is what I was saying, like when I did the analysis before, just because other people caused me damage doesn't mean that you didn't cause me damage. What are you responsible for? How much are you responsible for? That's the real question, right? Did you cause me damage? If so, how much? So KJ said, well, you didn't bring other people who caused you damage. And Toddy's argument, which I think is 100% right, is, well, I don't have to. I don't have to bring in other people that cause me damage. Whether or not other people cause me damage is irrelevant. We're concerned about how much damage you caused me. And if your argument is, well, I didn't actually cause all the damage, well, you know, if I ever get judgment against you, you know, you can turn around and sue the other people for the contribution if you want, but that's not my problem. You know, I don't have to bring them in this equation. And she's right. So that's contribution, if that makes any sense. I don't know if I'm coherent, but I'm trying. So that's what they're talking about when it says absent party, someone who's not here doesn't need to be added. To say joined is just to be added. So the person who isn't here doesn't need to be added to this lawsuit simply because they would have to pay for the contribution, because it isn't really all your damage. It's really someone else's damage. It's like, well, that's not my problem. You guys figure it out. She's right. There you go. Yeah. Additionally, Dawson and Starr have not claimed an interest relating to the instant case. An existing party may not obtain joinder simply because championing the interest in an absentee party. Joinder is contingent upon a requirement that the absentee party claim a legally protected interest. Defendants have failed to establish resolution of the action without Dawson, and Starr would be subject to any party of a danger of inconsistent obligation. Fair enough. Plaintiff's claims are based on numerous false statements. There's no risk of inconsistent court orders because there's no common cause. That's probably true. Likewise, defendants fail to identify any factors. Therefore, the failure to join should be denied. Yeah, I think that's probably right. I think the failure to join makes sense. Okay, then they object and move to strike the declaration of Michael P. Brown in its entirety as it lacks personal knowledge, lacks foundation, includes hearsay. First, Mr. Brown's statements referencing Zillow.com, the second paragraph, is inadmissible because it lacks foundation and personal knowledge regarding plaintiff's real estate acquisitions. No, he can state like what he knows, even if it's for the purposes of declaration. I think it's fine. Defendants used the statement and Zillow listing to prove the Westbrooks did not list their home for sale. However, the screenshots failed to accurately identify the Westbrooks anywhere in the image. No, I don't like that argument. The statement's tired statements hearsay screenshot and actually show a purchaser or sale of the property. Instead, shows Zillow, a third-party website, shares information has been obtained from a broker. It's fine for a declaration. You know, when it comes to the actual issues at hand, I think at least for me, I wouldn't buy this argument. You know, at this stage of proceedings, I wouldn't buy it. You know, when we come to trial or something later, we need it. But for the purpose of the declaration, no, I don't like these kinds of arguments. But that's me as a theoretical judge, right? I don't like these kinds of arguments as a theoretical judge. It's like, we'll bring them in as a declaration. We'll rely on them for as much credit as they're worth. Especially at a preliminary stage, because all we are on preliminary stages, right? We're on motions to dismiss at this point. So we have to take, on a motion to dismiss, we have to take everything the plaintiff says is true, unless it's absurd. So, we have to take everything the plaintiff says is true on a motion to dismiss, unless it's ridiculous. So who cares what the defendant or what they say in some affidavit? It doesn't matter. It doesn't matter to the motion to dismiss. It doesn't matter at this stage. Right? So they say, well, here's some information. It's like, I just don't care right now. Like, the only thing I care about is whether or not the plaintiff's causes are strong. So I care a lot about the plaintiff and some of their stuff, but like, some random declaration of the defendant's friend or whatever, it's like, I don't care. I don't care. It doesn't matter right now. Maybe later. Not now, right? It's just, yeah. Do they have children? I don't know about children. Why are you asking me? Yeah, it's to prove they live there. I understand the issue, but we're not at trial. We're on a preliminary stage. So, like, right now doesn't really matter. And it goes to and also doesn't necessarily even go to the truth of the point. It isn't necessarily even offered for the truth of the matter asserted, too. Which is another thing for hearsay. It's not even offered for the truth of the matter asserted. As such, it's offered for what they did with that information. So if they knew about the Zillow listings and they used that as part of their basis of making their claims, then the fact that it's true or not is irrelevant. The fact is their response to it. So it's not even necessarily being offered for the truth of the matter asserted. So it's not necessarily hearsay either. So even a trial is not necessarily hearsay. And for the purposes of preliminary motion, it's like, But even at trial, I don't know it's necessarily hearsay, because it isn't like, were you living there or not? The question is, presuming that they knew about this at the time they made the statements, right? So presuming they were aware of the Zillow listings, and that was part of the basis of why they made those statements, right? I'm not offering it for the truth. I'm offering it for why I made those statements, which is different. So it's not hearsay, or it's a hearsay exception to be more proper, but actually, no, it's not hearsay at all, because it's not being offered for the truth of the matter asserted. So I'm not even sure that it's technically hearsay, and certainly not for purposes of the preliminary hearing. It's not clear that it's being offered for its truth. It's being offered for how they reacted to it or responded to it. Maybe, possibly. Could be. We have not gone to discovery. We have not gone that far yet. No, we're nowhere near discovery yet. We're not gone that far yet. Third, Mr. Brown failed to provide any evidence Westbrooks lived in the house after they purchased it, which they never did. And whatever. That's not necessarily the issue. Second, the remainder of the statements, which were about glam life gurus, accounts are also admissible because Mr. Brown lacks the foundation of personal knowledge to test who used Twitter and accounts on those days. Mr. Wilkes does not manage, post on, or the Glam Life Bro. The most highly recognizable person, for personal safety reasons, does not want the general public to know where she is, so her posts are not evidence of her location. I don't agree to that. I mean, it's some evidence. Now, I mean, it is evidence. It may not be correct, but it's evidence. So, like, it may not be true, but to say it's not evidence is wrong. It is evidence. Right. Now, there may be reasons that it's not correct, but say not evidence at all, that's wrong. Mr. Brown's improperly offense is supposed to establish that Los Angeles, not Washington, was her home at the time. Relying on these statements as evidence, defendants spent over a page and pure speculation and conjecture where Westbrook was living based on date and location of each post. Yeah, kind of. Lacks personal knowledge. Yeah. I mean, without me getting into it, I'm not particularly inclined to grant any of that right off the post. So, for reasons, we respectfully request the court to deny motion to dismiss. Well, it won't be dismissed because we never moved to dismiss the defamation, which is the core cause of action. Unless the jurisdiction argument wins. The jurisdiction argument for Toddy seems a little thin. Now, of course, it's not like the biggest blow in the history of time, because even if the jurisdiction argument wins, it doesn't matter. Well, it doesn't matter that much because you'll just file somewhere else. So, like, if this case gets tossed for jurisdiction, which I think is a possibility, perhaps a strong possibility. So if this case gets tossed for jurisdiction, it's not like Toddy can't refile. So if the case gets tossed for jurisdiction, she can always file where KJ lives, which is what, Missouri? So she could always file suit in Missouri, if no other place. I mean, that's a gimme. So, like, if the case gets tossed for jurisdiction, we just have to start over somewhere else, which I'm sure they will. So it's not that big a deal. I mean, it's not a huge deal. The jurisdiction does seem a little thin. So based on my limited knowledge, which I admit my limitations, but based on my limited knowledge, I think that the jurisdiction is a little thin. I think that there's not a lot here to suggest particular activities in Washington as opposed to anywhere else. And so it seems a little thin. And if they were basing some of their stuff, if they thought that she lived in Los Angeles, if they thought that based on Zillow listings or otherwise, so they didn't know that they lived in Washington or whatever, and it's like, the jurisdiction stuff seems a little thin. So I'll be interested to see what Emily thinks. And, again, if she has a stronger opinion about this than me, then feel free to defer to her, because my opinion, I feel, is weak. So I'm more than willing to be overruled on this one. This is not one I'm willing to go to the mat on. So if she says, that she feels confident that jurisdiction is there, then I listen to what Emily says. But based on my limited impression and based on my limited reading, it seems a little thin. And but that being said, I also have to be cautious because I know courts do like to keep jurisdiction, because who likes to give it up, right? So every court likes to keep jurisdiction. So I'm also cognizant of that. So with all that being said, I mean, I would tentatively say that jurisdiction would be a tentative winner for KJ, but I'm more than willing to be corrected and more than willing to be proven wrong on that one. That's not one I'm willing to go to the mat for. So I guess we'll see, but it seems a little thin to me on the jurisdiction stuff. But if we get past the jurisdiction stuff, I mean, she never moved to dismiss the defamation. So, and the IIAD stuff, the negligent infliction of emotional distress and the harassment stuff looks pretty good. You know, if she had actually argued the defamation stuff, the stuff wouldn't look as good. Even with the same argument, it wouldn't look as good. Because if the core of the case goes away, it's like sweeping the leg, you know? It's like it's all gone. But she didn't do that, so if the jurisdiction doesn't work, then, you know, Toddy should keep going on. So, you know, let's go. So, we'll see. I'll be interested to see what Emily has to say about it. Yeah. Excuse me. All right, so let's read some more. So we've got a sworn statement from Toddy. How long is this thing? It's probably pretty long. Hold on, let me see how long this is before I get too deep into this. Oh, it's only 5 pages long. The declaration from Toddy is only 5 pages long. Fair enough. She's 18. She's a resident of the state of Washington, born in Washington, bank accounts of Washington, investment property Washington. All my businesses are Whopping. I do not own or rent any property in California. Okay. I own Toddy Incorporated, which is the entity through which I manage this. I'm chief executive officer. Maintain my work. Part of my business entails critiquing beauty products and posting these critiques on social media, including YouTube. I have 9 million subscribers. My YouTube channel is called Glam Life Guru. My Instagram account is called Glam Life Guru. My Twitter account is called Glam Life Guru. I do not manage my social media accounts on my own. Many of my social media posts have been created by others, including videos of his assistants. Because I have so many followers, I'm highly recognizable. I wouldn't recognize you if I saw you, but, you know, that's cool. For my personal safety, I do not want the general public to know where I'm all the times. As part of my work is social media, travel to work, and post public posts. I'll post photos and pictures at random times on non-locations so people do not know where I am or where I live. I was born and raised in Washington. The bulk of my family is rooted in Washington. Much of my family, including my mother, father, stepfather, grandfather, sister, and extended family is in Washington. So she's a Washingtonian. She's loud and proud about the Washington. She wants you to know she loves Washington very, very much. For a period of time, my husband and I lived in California, but we started to move to Washington late 2018, signed a lease agreement, officially took possession of our home. Buzz and I personally filed tax income to the state of Washington. Due to confidential information, we do not wish to make our returns public or otherwise waive privacy. Fair enough. Below is a screenshot from my Instagram account. The picture was taken below with me in Washington residence. Okay, well, there's a Toddy in her Washington residence, which looks pretty baller. I mean, she doesn't have 9 million followers, but still, man. She's got nice windows. Yeah. I want windows like that. That looks nice, I have to say. Defendants in this case have published approximately 80 videos about me. My video titled Sephora Arrived at My House. Person I know to be Katie Jo Paulson states, defendants start digging into my background, looking all over the place, different searches, Truth Finder, background. My husband has downloaded a true and correct copy of the video and placed it in a Dropbox folder at the court convenience. And said video may be voiced at. Should we go to her Dropbox folder? Let's go to her Dropbox folder. Because we can. So she has it was uploaded by Michael Saltz. Honest commentary. Sephora rides at my house on answers question 2, including Tada. Oh, man. Thank you, Michael. So if you want to go watch Sephora Rides at My House from Without a Crystal Ball, you can go to Michael, you can go Salty's lawyer, you can go to Salty's Dropbox over here and download it yourself. Yeah, good times. In a video until the past, James and Toddy Westbrook don't want you to know. First I know began discussing the investigation, starting approximately 13 minutes of the video. Defendant talked about the research they've done, discussed my personal history in Washington. Defense also stated they have documentation for all the information, including court records. I declare under penalty of perjury, blah, blah, blah. And also there's another Dropbox if you want to watch the video, the past James and Toddy Westbrook don't want you to know about. So if you don't want to get your fix, from the Without a Crystal Ball channel, Toddy has you covered. You can get it from the Dropbox of Salty. And then we have 55 pages of James's thing, which we are definitely not going to read because I am completely broken and tired. I think we've reached the end of this stream. We've reached the end of the stream. Yeah, I think we've reached the end of the stream. 2 hours into this thing. So, my analysis is the IIED thing. I think is still crap because IIED is really hard. The negligent infliction of emotional distress looks pretty good, specifically because we have a Washington State Supreme Court case, if I read that correctly, which I'd like to think I did, which said that claiming anxiety and depression is enough of a diagnosable condition. That does seem to be a fair read of that Washington State Supreme Court case, which the federal court is obligated to take as a given. That is the operative law, so they did allege that. So the negligent infliction looks promising. The civil harassment, if they're quoting statute properly, looks good. What else was in there? Yeah, the failure to join argument is a total winner. That's an easy one. And the Consumer Protection Act, I'm not feeling that really strongly. So I think the IID is a loser and IED is a winner. Consumer protection is a loser. Civil harassment is a winner. Failure to join argument is a winner. Request to strike evidence, loser for me. Not that it really matters really one way or another. And so then it just comes down to the jurisdiction issue, which may or may not matter in the end because they'll just refile it. So yeah, it may not matter very much in the end. So there you go. Yeah, really good stuff. Yeah, I'll be on with Emily sometime next week. I'll be interested to see what she says about the jurisdictional stuff. That'll be particularly entertaining. So we'll see. But if you have not done so already, may I please ask for all you people to subscribe. The people in Alaska, the people in Washington, the people in Scotland, the people in Australia, the people in New South Wales. I think I saw someone from New South Wales, and some people in South Carolina and Tennessee and everywhere else. Please subscribe. Help me grow. Emily has, I don't even know how many subscribers. Lots. And I like also lots. I think she's up 50,000 me, so she's up to 60,000 or 70,000, something in that territory. Last time I checked. So I'd like that. Please subscribe to my channel. I also do legal analysis. I'm funny, and I'll beat my head against the wall for your love. And if you're not done so already, if you please like the channel, like the stream, I'd appreciate it. And if you're not done so already, for 99 cents a month, because I'm much cheaper than Emily. I'm a cheap date. Emily will charge you $4.99 a month. But I'm a cheap date. I'll charge only 99 cents a month. For 99 cents a month, you too can become an uncivilian. And you can help this channel grow. And if you give me 99 cents a month, 3 things will happen. Number 1, you will get your name in green. Number 2, you will get access to my batch records and other off-stream content. For example, sometimes I play games or video games and I make them members only after I'm done because they're off-brand. And number 3, I will like you more. So if you would join that, that would be great. If you could join that, and I'd appreciate it. And I appreciate all the people who are here from Emily, for all the people who are late night holdouts like me. I really appreciate it. Thank you. $5 from Julie V. Oh my God, thanks for staying up and going over with this. No problem. Finland, South Carolina, Victoria, Alaskan, Michigan. Yeah, she's got 70,000. So I need to pick up 50. I need to pick up 50,000 subs. I need to pick up 50,000 subs. She's fun though. I am also fun-ish. And also, of course, Merry Christmas. Merry Christmas to all, and to all, a good night. Later, my friends. Cheers and goodbye.